All right, see some more people logging in. Again, if you do have questions, please feel free to put in the question and answer section. I don't have a lot of questions submitted ahead of time, so this is really kind of a free open office time now. So if you do have questions, submit those. Otherwise, there's a couple things I want to talk about, and then we do have a question that's submitted. But again, feel free to go to the question and answer section and type in that question before we get started. And with that, let me see here. All right, we will go ahead and get started. Sure. All right, this is going out. We are recording and streaming. We got everything going on. Perfect. All right. So like I said, my name's Chris Berry. We do these wisdom webinars every week. So if you do have questions, this time is for you. So if you do have questions, please put that into the question and answer section, and I'll go ahead and answer that live. These are unscripted. They're really just here to provide you value and knowledge. Any information we share, again, it's going to be general. If you want to see how this applies to your situation, please let's sit down or have a phone conversation, because one of the things that I'm going to talk about today is just that there's a variety of different places where you can get information, and not all the information that you get might be appropriate to your situation. So if you do have questions, please make sure to submit those questions, and I will go ahead and either answer it live. If it's a more detailed question, because my head is only so big, there's only so much I can store in my head. If I need to circle back with you, then I'll circle back to answer your question. But I do want to make sure all of your questions get answered, okay? And so with these webinars, I always like to start with a positive focus, something positive that happened either professionally or personally. And if you want to enter something in the chat that is something positive that happened over the last week, feel free to go ahead and do that, and I'll read it out. I'll protect your personal information, but if you have something positive that happened the last week, I always like sharing that. It's something I do with my family, where we sit down and we always share a positive focus before we start our dinner, just something that we're grateful for. So for me, I'll start off positive focus, really twofold. One, personally, one as a parent. Personally, I had a total hip replacement about a month ago, March 9th, and I'm already in a lot less pain. I can walk a lot further than I could prior to the surgery. So 42 is kind of young to have a total hip replacement. I played a lot of sports. I'm a big guy, did a lot of basketball and soccer. So there's a lot of wear and tear in my joints. And prior to the surgery, I couldn't even get through a trip walking through Costco without being in a ton of pain. And already I can walk over a mile. Granted, I'm using a cane and everything, but it just feels good to see it going in the right direction. So my first positive focus is medical improvements. The fact that they can literally cut out bone, replace it with titanium, and throw it in there and be pain-free, that's pretty awesome. So I'm a big fan of that. And then also personally, my kids are 10 and 8, and I am coaching them in soccer. And again, one of the reasons I wanted to have the hip replacement is be able to run around and play soccer with my kids, but they just started their soccer season. My daughter just had her first soccer scrimmage, and it's just great to be able to spend time with my kids, coach them in soccer, and just really enjoying that. So those are my positive focuses. If you have a positive focus that you want to share, feel free to put it into the chat. Otherwise, I'll get started and get into the questions and answers. And again, if you do have a question, I don't have a lot of questions submitted ahead of time. So if you do have a question, now's a great opportunity to submit that, and I'll go ahead and address that today. And so I have 2 questions submitted, and I'll give some more time for some more questions to come in. So if you do have a question, feel free to put that in the Q&A section. I'll go ahead and address that. But in the meantime, there's a couple things that I just wanted to address right off the bat. So I'm going to share my screen here. So the first thing is changes with regards to the Secure Act. So the Secure Act affects really IRAs and 401ks, anything that is pre-tax. And so the Secure Act, it actually passed back in December of 2019, which seems like a lifetime ago. And so we started off doing a lot of workshops and face-to-face workshops talking about the changes of the Secure Act. But then the pandemic happened, and so we had to switch to webinars for our education with regards to Secure Act. So the Secure Act really did two things. And the two things that it did is, first, it pushed back the RMD age, so those required minimum distributions, so that age that you have to start taking money out of your IRAs or 401ks. It used to be 70 and a half, which is a weird age. Like, does anyone know what their half birthday is? Most people don't, other than my kids, because they think they should get a present on their half birthday. But most adults don't know when their half birthday is. So prior to the Secure Act, when you turn 70 and a half, you would have to start taking out required minimum distributions from your IRAs or 401ks. So whether you liked it or not, you had to pull money out of these pre-tax accounts and pay the tax. And so what the Secure Act did is that it pushed the RMD age back from 70 and a half, 72. So now if you're younger than 72, you don't have to take any money out of your pre-tax accounts. Now, that said, you're not forced to take money out. I would suggest that it probably does make sense to pull money out of your pre-tax accounts sooner rather than later, because most people think taxes are going up in the future. So what the Secure Act did is it pushed back the required RMDs, or pulling money out of the pre-tax accounts, pushed back the requirements from 70 and a half, 72, but I would suggest that still you explore a strategy of pulling the money out sooner rather than later. And that's really been one of the things that we've been spending a lot of time the last couple of years, the last couple of months, working with clients to pull money out of those pre-tax accounts, because most people think taxes are going up in the future. Now, the second thing, and this is really the big change that we just saw a couple days ago, is that when you leave IRAs to the next generation, prior to the Secure Act, they had to take out the taxes over their lifetime. So if you were leaving pre-tax money to the next generation, they could stretch out the tax burden over their lifetime. And this really became interesting when we left money to like grandchildren, where their age was so low, their RMDs would be less than whatever the account was generating. But with the Secure Act, what they did is they instituted a 10-year rule, where now all the taxes have to be paid within 10 years. So this was our understanding, is that all the taxes would have to be paid within 10 years, with the idea that, okay, you don't have to pay the tax all in year one if you're leaving it to the kids or the grandkids, or year two, year three, just all the taxes have to be paid within 10 years. So that was everyone, and literally, I mean, everyone's understanding of the IRS rules. And then a couple days ago, about a week ago, the IRS released a publication that threw the whole investment, the whole tax world for a loop. And this just shows I share this to show that, like, there's like logical decision making, and then there's what the government does. And so what the IRS said, and this is completely different than everyone's understanding, completely different than everyone's reading of the IRS code, including people like Ed Slott, who's a very well-respected CPA. Wall Street Journal has called him America's CPA. I'm friends with him. I've trained with him. Anyone else, if you look to the news or any commentary on the Secure Act, the story was that all the taxes have to be paid within 10 years. Now, the understanding that everyone had based on what the IRS proposed is that just all the taxes had to be paid within 10 years, meaning in year one, you could pay zero tax, year two, zero tax, year three, zero tax, but then year 10, then the tax had to be paid. So you could defer, and then pay all the tax in year 10 for the kids, right? Well, what the IRS said, and this is as of March 25th, they released a publication to say that RMDs are still due years 1 through 9 for beneficiaries. And then year 10, all the tax has to be paid. At the end of the day, it doesn't really change things a great deal, but what it does is it creates more of just a reporting issue for those beneficiaries inheriting pre-tax accounts. So we already knew that taxes had to be paid within 10 years when you inherit an IRA, but everyone's understanding was that you could just defer, and then year 10, you could pay it. You could pay it all up front at year one. But now this IRS ruling says that if you were to defer it, at the very least, RMDs would have to be paid. So it doesn't really change anything from a planning standpoint. It's just another arrow in the quiver of maybe you should not be leaving pre-tax accounts to the next generation, because now not only do they have to pay all the taxes within 10 years, which could drive up their income tax, but on top of that, they have this reporting issue that we didn't think we had in the first place. So a couple takeaways from this. Again, first, think about what you're leaving to the next generation. Is it pre-tax money? Is it post-tax money? Ed Slott and most experts, myself included, say, okay, now that we know taxes are going up, now that we have the Secure Act, now that we're $30 trillion in debt, everyone thinks taxes have to go up in the future. It probably makes sense to look at paying the taxes sooner, not only for your retirement, but also now what you leave to the next generation. And then with this change in the interpretation of the Secure Act, which just happened in 2019, now the kids are going to have more of a reporting issue if you do leave pre-tax accounts to them. So again, the government is always going to change things. We're watching it. And then the second takeaway is looking at moving money out of these pre-tax accounts sooner rather than later. So that was something that we just saw across that happened within the last couple of days, the last week. We had an article that we just emailed out where my friend Ed Slott, he actually just talked about this, how this was kind of blindsided everyone. At the end of the day, it's not really going to change a lot of the strategy we've talked about, but it's just more of a reporting issue for the next generation. So that's the first thing that I wanted to bring up, is this change in the Secure Act. The big change in law doesn't really change the strategy. We've always been talking about moving the money from pre-tax to post-tax. A question that just came in on this is the spouse exempt from the 10-year rule? The answer is yes. So this is not talking about a spousal rollover. This is talking about leaving it to the next generation, leaving pre-tax dollars to kids or to a trust. We have the Secure Act that we have to worry about. If you're leaving the pre-tax accounts to a spouse, they still typically do a spousal rollover. The rules there remain the same. It's when we're leaving it to the next generation that we have to worry about the Secure Act. So again, typically 9 times out of 10, we're still naming the spouse as a primary beneficiary of 401ks and IRAs. It's just, how do we leave it to the next generation? Whether you leave it outright to a beneficiary or outright to a trust, we now have to operate within the Secure Act. A couple of questions that come in based on this. Do beneficiaries get the RMDs during the 10-year period? The answer is yes. So if we do leave, let's say $1 million IRA, let's say the IRA, and I'm just making up numbers, is $50,000. they would have to take out that RMD of $50,000 and pay the tax. Another question, implications of naming beneficiaries of grandkids versus skipping your kids. So in the past, prior to the Secure Act, if we were leaving pre-tax dollars to the next generation, there was an advantage to naming younger people as beneficiary of those IRAs. And we would structure separate trusts. We call them IRA inheritance trusts, where now we don't want like a grandchild who's 5 managing the money, but we do like the fact that they're so young, their RMD is so low. So we would name a inheritance trust as the beneficiary to inherit the IRAs. And then as they inherited these IRAs, they wouldn't manage it. We would have someone else manage it. And because they were so young, their RMDs were so low that we were almost creating an annuity for the next generation, where their RMDs might be 1%, but if we were gaining 3%, we were creating this like pension for the grandkids. When the Secure Act passed, that really defeated that whole strategy, because if you were to name the grandkids as the beneficiaries, regardless of their age or what the RMDs are, now all the taxes still have to be paid within 10 years. So I'm not saying we don't name grandkids as part of the planning, but we used to have this huge tax opportunity where we would name the grandkids as beneficiaries. They'd have such low RMDs. We stretch it over their lifetime. Now we could almost create annuities or pensions for the grandkids where the RMD coming out was 1%, but we were earning 5 or 6%. We were growing this legacy for the grandkids. With the Secure Act, we cannot do that with IRAs anymore. So again, that's where a lot of experts, myself included, Ed Slott, IRAs used to be one of the best things to leave to the next generation. Now those have dropped to the bottom. Instead, we want to leave things like Roths or life insurance or whatever would be tax-free to the next generation. Let's see. Whoops. All right. I answered that. Any change to the Roth 10-year distribution? So a question people have is with regards to Roths. So you do not have to take out any required minimum distributions from your Roth IRAs while you're alive because you've already paid the tax. The tax is now, or the growth is now tax-free. But when you leave it to the next generation, even though they don't have required minimum distributions where they have to pay tax, they still have required minimum distributions where they have to take out money. Okay, so when you leave a Roth to the next generation, even though they don't have to pay tax, they still have to take out a RMD. And this is where the Secure Act clarified it, is prior, when the Secure Act first passed, we didn't think they had an RMD. We just thought that they had to take out all the taxes, or they had to take all the money out of the Roth within 10 years. They did not have to pay tax because the tax was already paid. They just had to take it out of the Roth and do something else with it. Now, with this clarification of the Secure Act that no one expected, and you know what, I'll give you a Starbucks $5 gift card. I'll buy you coffee if you can find someone that talks about the Secure Act any difference within the last year than what I'm talking about it now. No one expected this, okay? But now, with the Secure Act, all the money has to be pulled out of the Roth within 10 years. And then on top of that, they have to take out required minimum distributions based on their age. So there's going to be a little amount that's going to be required in year 1, year 2, year 3, year 4. No taxes are due. They just have to take the money out. And then by year 10, all the money has to come out of those Roths. So again, this recent publication by the IRS really doesn't change strategy per se. It's just, it's a head scratcher. Like, it doesn't really make sense. No one expected it, and it creates more of a reporting issue than anything else. So Jim, that answers your question. With the Roth 10-year distribution, they still have to take out RMDs. However, still they do not have to pay tax. Alan, This does apply to inherited Roth IRAs as well. Again, they do not have to pay a tax. They still have to take everything out of the Roth within 10 years. Now with this change, they owe a RMD where they have to take out a certain amount each year. They do not have to pay any tax. Again, it's not really changing any of the strategies we talked about with the implementation of the Secure Act. It's just changing some of the details of it, et cetera. Phil writes in, is the RMD requirement based on a 10-year time frame? Again, this is where it's like a head scratcher for all of us. The answer is no. Like you would think that it's like 1/10 of the value every 10 years for 10 years. The answer is no. It's going back to the IRS tables that we use when we're talking about taking out RMDs. And there's two big ones. One is yours and then one is a single life. And so, for example, yours, and I'm just kind of ballparking for right now. When you turn 72, your initial RMD might be 3.5 or 3.65%, meaning you have to pull that money out, okay? When it becomes an inherited IRA or inherited Roth, let's say you're age 40, your RMD, again, it's based on your age, might be 2%, okay? So this is where it's like a head scratcher for us and more of a reporting issue than anything else. When you pass away, you leave this to the next generation, they have to take out their RMD based on their age. So it might be 2% in year one, 2.3% in year two, 2.3% or 4% in year four, ongoing. And then at year 10, they still have 90% still in the IRA or the Roth. Now they have to liquidate the whole thing, right? You would think logically it might be 1/10 of 1% for 10 years, but it's not. So that's why, like, everyone that's looking at this publication, we're all like, what are you doing? Why are you doing it this way? Like it's not logical. It doesn't make sense. But it is what it is. So as of right now, this is the rule. What we've been talking to clients about is if you're looking at doing Roth conversions or pulling money out of IRAs, or you have an inherited IRA, just like last year, mid-year in March, they passed the CARES Act that changed that you didn't have to take out a RMD. We're telling clients that unless you have a need, let's wait until all this kind of fleshes out this year. And then in the fall, so September, October, November, let's look at end of year tax planning. Let's look at RMDs. Let's look at Roth conversions. Let's look at pulling money out of these accounts just so that everything settles, because we foresee with the change in presidency, with the pandemic we had last year, with the $30 trillion in debt, with these infrastructure improvements that this administration is proposing, there's a lot of things up in the air right now. So we look at it as we have this tax year where we're still operating within the Tax Cuts and Jobs Act. We kind of know how things are going to work. Let's use this tax year, and near the end of the year, let's do these end of year kind of tax planning issues. Other comments or questions? So what is pre-tax moving strategy to move money out of? Okay, yep, we'll talk about that in a second. So Roth IRA, all right. What if my inherited Roth IRA was a Roth conversion and the 5 years are not up from the Roth conversion? Okay, so if you've done a Roth conversion, that's like a different conversation. Okay, so when you do a Roth conversion, depending on your age, the idea is that you wait 5 years before you start pulling money out. That's a completely different conversation. And really that's unaffected by the Secure Act. So let's put that one to a side. Santos writes in, if you pass, does your spouse have to take out Roth in any specific time frame? So if we name the spouse as a beneficiary, and this is typically what we do, then it becomes a spousal rollover where that surviving spouse does not have to pay any tax, does not have to take out any RMDs, especially if it's a Roth IRA. So we don't have the rules of the Secure Act kicking in if we leave it to a spouse. With a Secure Act, we're talking about leaving it to anyone other than a spouse, typically. There's some exceptions, like if you have a disabled child, but really we're talking about leaving this to anyone other than a spouse. So if you do leave this to a spouse, then you don't have to worry about the Secure Act. A spouse doesn't have to worry about RMDs. Eileen writes in, so a Roth 10-year distribution, it seems like the kids inherited the Roth, should take out all of the income in the first year, move it to regular investment so that there is no tax and they don't have an RMD. Is that correct? Not necessarily, Eileen. So when you leave a Roth, that money is tax-free. You've already paid the tax. So the growth on the Roth is tax-free. So when I'm talking about RMDs for the kids, they have to take money out of the Roth, but they don't have to pay tax on it. Okay, so I'm not advocating for them to pay out, to pull all the money out at once with the Roth. In fact, it might be the opposite. We might want them to keep it in a Roth as long as possible. But at the end of the day, really, and this gets to one of the chat questions that come in, at the end of the day, really, when we're talking about moving money and creating a tax-free plan, so this is something we're really focusing on our firm, is tax planning, not just tax preparation, but tax planning. This is one of the focal points of what we do. And what we have is we have these different tax buckets. So first we have what we call taxable accounts. Okay, so these are things like checking, savings, money market, cash. And the thing here is that you have to pay tax on any gains, right? And then we have our taxable accounts, or tax deferred accounts. So tax deferred accounts would be like IRA. This is money you haven't paid taxes on. 401k, 403b, 457. And the important thing here is that anything you pull out of here is taxed at ordinary income. And that's really whatever the tax brackets are at, right? And then third, we have, and now to clarify, we call this income tax free. Okay, so these are things like Roths, cash value life insurance, 529s that have to be used for education, health savings account that have to be used for healthcare, right? So the nice thing about this is that the growth is tax-free. The downside of these accounts, and this is something that's becoming a bigger issue with this, with the current tax, or the current infrastructure here, current government, is that we have to worry about estate taxes. So when you pass away, Roth IRAs count towards your estate tax. And then we have estate tax plus income tax free. And this is where we get into irrevocable life insurance trusts, family inheritance trusts, charitable remainder trusts. All right. So the question was like, what is a kind of tax plan look at? The idea is that we're moving money out of these accounts because we know taxes are going up. Let's move it to a taxable account. Whoops, that's a horrible arrow. Income tax free or an estate tax free. And I'll tell you, a majority of my clients, when I initially sit down with them, a majority of their money is sitting in these 401ks, IRAs, because they subscribe to this old paradigm of investing, of just sock away as much as you can in the 401k IRA. But the concern is now we're $30 trillion in debt. Most people think taxes are going up in the future. So now we needed to try to figure out a tax plan to minimize taxes. And so tax planning really comes down to two steps. One is, so tax planning really comes down to two steps that we're doing with our clients. And like even yesterday, I met with 5 clients, and 3 out of 5 clients, we were having this discussion. How much to move? So that's kind of the science and the numbers behind it. And the second piece of it is where to move it to. And this is the art of things, okay? And this is where, I'll tell you what, there is a lot of bad advice on where to move it. The assumption is we just do Roth conversions, but depending on your situation, a Roth conversion might be the last thing that you want to do. There's other options depending on your situation. So, yeah, so that's to answer KE's question. What is the pre-tax moving strategy? Max out annual Roth conversions? Not necessarily. It is all really about figuring out how much to convert on it or move to on an annual basis. And then the second piece is where to move it. And for every situation, it's a little bit different. Okay. All right, answering questions here. Nikhil, besides the Secure Act that has passed, what anticipated tax changes impact estate and tax planning? For funding, there's lower tax of the Biden administrator, moving. Okay, all right. So here's a common question that I'm getting a lot of is where are taxes going in the future? Let me save what I'm doing here. All right. So where are taxes going in the future? So there's 2 big things to think about. First is the Tax Cuts and Jobs Act. Okay. This runs from 2018 and it's scheduled to run to 2025. Okay. But I'll tell you what, Biden ran on a proposal, regardless of where your taxes are, of repealing this. And this could have 2 effects. One is income tax, where now your 22% tax bracket will be going to 25% if it's repealed. 12% is going to 15%. If you're at the 24% tax bracket, you're going to 28%. So I have a lot of clients in retirement that they are right now in that 24% tax bracket. And so under Biden's proposal, you're looking at more income tax if he repeals the Tax Cuts and Jobs Act. The second piece of that is with regards to estate taxes. So right now, if you have less than $11 million, you don't have to worry about the estate tax. But if the Tax Cuts and Jobs Act is repealed, that's dropping down to $5 million. So if you add up your assets, your real estate, your life insurance, your Roths, your traditional IRAs, if it's greater than 5 million, you're going to have a tax issue. And then Biden and Sanders proposed a recent bill that's going to lower it even further. So now the estate tax exemption is at $3.5 million. Okay. So really at the end of the day, there's 2 things we need to take into account. One is going to be income tax planning, looking at tax brackets. So this is moving money from pre-tax to post-tax or tax-free. And this is something that everyone should be looking at. This is where we're looking at your tax bracket, figuring out how much room we have in the tax bracket and calculating how much can we move. And the second piece is where do we move it? Do we do a Roth conversion? Are we moving it to an irrevocable life insurance trust? Are we moving it to a family inheritance trust? And then the second big thing is estate taxes. So if you're on this call and you have more than $3.5 million of total assets or $5 million of total assets, there's some things that we need to do right now before this window closes to look at protecting this from estate taxes. Because again, there are opportunities right now before there's a change in law utilizing the estate and gift tax to take advantage where we can move $5 million out of your estate, you remain in control, but now it's removed from that estate tax calculation. And this is something that has to happen before the estate tax exemption drops. So these, I can't stress this enough. These are two huge things that we need to think about. Marginal tax brackets going up. This affects everyone. And we look at your tax return, we look at your income, we look at where your income's going to go. And the second thing is, if you do have an estate that's greater than $3.5 million, these two issues we need to take into account, and this needs to be done this year, okay? We don't know how long this window of opportunity is going to last. So we've been banging this drum for a while that the biggest risk I see is tax risk, and the biggest opportunity based on our current laws is planning for taxes, both on marginal income taxes and then now based on the Biden and Sanders proposals on estate taxes. All right, so with that, a couple of questions coming in. So how do we access recordings of previous sessions? Go to our YouTube channel. Just shoot me an email if you're not subscribed. I can share that with you. And we record all of these go to our YouTube channel. I think that answered Nikhil's question with regards to the Biden proposals. Anonymous writes in, should we consider giving our assets away to use up the current gift tax exclusion before it is reduced to $1 million? I'm not a big fan of gifting. Instead, if you wanted to move money out of your estate, if you're concerned about estate taxes, then what I'd recommend is we can set up what we call a family inheritance trust, where you can still manage it, but now it's removed from the estate tax question. And then you can divvy it up to the kids or grandkids as much as you want. So big picture, think of it like, whoa, that's horrible drawing. So assume right now we have $11 million. Oh, holy cow. We have $11 million that we have a state and gift tax exclusion. Let's assume in the future that's going to $3.5 million, right? So what we can do is this money here, let's move that out of your estate, and now we move it into a family inheritance trust where you can be the trustee, you can manage it, but now let's say this $6 million, you can decide how that's divvied up to the kids, the grandkids, you can manage it. So I'm not a big fan of gifting it outright, but instead I'd rather gift it to something that's out of your estate for estate tax purposes, but you can still manage, and then you can divvy it up between the kids and the grandkids and charities however you like. But that's really a big opportunity. I have a client, has $12.5 million, has some real estate and businesses. We're moving this to the family inheritance trust. He can still control it. He can still manage it. Now it's out of the estate. And then if he wants to gift portions or give some to the kids or grandkids, he can do it under his control versus just outright gifts where now it's lost. Now, if one of the kids gets a divorce, a creditor action, bankruptcy, that money is lost. So it's maintaining control, but still building an asset protection. So yes, we should look at moving money out of your estate if this is money that you're not going to use. But instead of gifting it outright, I'd prefer to gift it to a trust for a variety of reasons. Could we gift real estate? The answer is yes. That's a perfect thing to gift. Real estate, gifting, business interests, all of those are perfect opportunities to gift money. This is from Tom and Terry. Chris, are the 11 million, 5 million, $3.5 million per spouse? The answer is yes. So it is per spouse. As of right now, we have what's called portability. That could go away in the future, but as of right now, that is per spouse, okay? Assets in a fit included in Medicaid look back. The answer is no. So the money that you gift to a family inheritance trust, it is out of your estate for estate tax purposes. It is out of your estate for Medicaid look back purposes. Change from joint spousal trust to separate trust. So in the past, we would utilize a lot of separate trusts because in the past, the estate tax exemption was locked into just one spouse each. So each of you would have a coupon, and if one of you passed away, that coupon would disappear. So we used to do separate trusts to lock in both of those coupons. So if it's at $3.5 million, we would do an A-B trust, separate trust, where each spouse now would have their $3.5 million exemption locked in, so we could pass $7 million to the next generation. 2010, they had portability that said we don't have to do separate trusts anymore. So separate trusts are more complicated to administer, and I'm always a fan of trying to keep things as simple as possible. All of this is complicated enough, let alone adding in any type of additional complications. So if we can do a joint trust, think of a trust like a piggy bank or a suitcase. Now both spouses are holding on to. If one spouse passes away, everything remains for that surviving spouse. Typically, we're doing a joint trust if we have a married couple, unless we have kids from previous marriages or something like that. So we do not have to do separate trusts to protect against estate taxes. We would typically do a joint trust. All right, a couple of things coming in via the chat. So what is the pre-tax moving strategy? We talked about that. So do we need to meet with you to discuss where to move pre-tax accounts? I'd recommend that. So when we meet with you, need to bring our tax records. We do taxes for our clients. We do tax preparation. We have a CPA, and we do tax planning. If you do your taxes or you have someone doing your tax preparation already, that's great. What we would do is we would open up a secure portal so it's not floating around on the interwebs. And what we would do is we would ask for your last tax return, last investment statements, and that gives us a baseline to talk about the different strategies that are available. So yes. All right. That was all. Thank you. You're welcome. Yes, I appreciate that. It's good manners. My kids are 10 and 8, so we're always working on manners. Question that came in right before we met. Is there a way to locate a copy of a will, even though we don't know which lawyer provided it, etc.? Is there something to compel family members to produce a will? What are our options if a will was not filed? So when someone passes away, there's two key documents that are involved in terms of administrating their estate. One is a trust, which is a private document, doesn't have to be recorded or anything. However, any beneficiary is entitled to see an accounting, an inventory, and a copy of the trust. The other option is a will. All a will does is gives instructions to the probate court on how to administer that estate. And so a will is typically recorded at the probate court, especially if there's an estate. So if you're trying to track down one of those things, the best bet is to reach out to the law firm or attorney that prepared it if you know it. For example, any documents we draft, our information is included in there. The other option is you can go to the county where someone passed away or they own assets. And then if there was a probate estate, that's a public record. You can see the will and you can see whatever is going through probate court. That's going to be true no matter what state you're residing in. So if you had a loved one that did pass away in North Carolina, you would reach out to the county, the probate register to see if there was a probate estate opened, and then you would look to see if there was any will filed there. But even if there wasn't a will, and let's say there's a trust, there's certain requirements that are included in administrating a trust. One of those would be an inventory and an accounting to any named beneficiaries. So even if it was a trust and there wasn't a will, if you were named as a beneficiary, you'd be entitled to see how those assets were handled, and you'd be entitled to see what your cut of that was. So hopefully that was helpful. Mike writes in, how do we stay ahead of the retirement game, IRA, 4A, 401, etc., when government can change rules whenever they like? Yeah. This is a battle we're always fighting. Is again, I don't want to get political, but my goal, my feeling is that you can spend your money better than the government can spend your money. So if I can put more dollars in your pocket versus more dollars in the Internal Revenue Services, that's a win. That brings me this joy in life, right? And so that's really the focus of our firm. Is we work with good families to help them plan, protect, and preserve what's important to them. Protect against probate, protect against the IRS, protect against nursing home costs. So I don't have any magic wand answer to protect against taxes. Really, at the end of the day, it's looking at what are the current rules, where do we see things going in the future, and then figuring out what is, from a number standpoint, the best plan, and then also looking at the art of it. So how much should we move out of those pre-tax accounts? Or if you're still working, maybe we should rethink where we're accumulating wealth. This is a big discussion I have with a lot of my clients or my clients' kids who are still working. Maybe we shouldn't overfund those pre-tax 401ks. Maybe we should look at saving money in a Roth, saving money in cash value life insurance, saving money in 529, saving money in health savings account. I'm a big fan of diversification, not just diversification in terms of having all your money in one stock, but diversification of the tax buckets. Maybe we shouldn't be retiring with $4 million pre-tax, okay? Or if we are in this situation, congratulations, you did a great job of accumulating wealth. Now we need to diffuse that ticking tax time bomb that's in that $4 million pre-tax accounts. What is our strategy to diffuse that ticking tax time bomb? How much should we move and where do we move it? All right. Additional questions here. Assets in a FIC controlled by the giver but can't be used by the giver. Yes and no. So you would be the trustee of the trust. You would decide how it's invested, but you cannot take the money directly out of the trust, put it back into your name. You could get the money back, but we'd have to go through one extra step. But it is a way that you can control it. We would just remove it from your estate for estate tax purposes. Another question that comes in from Anonymous. Does an adult child who's let me try that again. Does an adult child who's excluded from a trust as a beneficiary, are they entitled to a copy of the trust from the trustee? That's a tricky situation. So I will give you a legal answer, but then also there's more of a family dynamic answer. The legal answer is that the only people entitled to see a trust are named beneficiaries. So if they're not entitled to anything, they're not entitled to necessarily see anything. But what that's going to lead to, so this is the real world family dynamic issue, is that now they're going to, in this vacuum of information, because they don't know what's going on, they're going to create their own scenario. And now they might be more likely to now hire an attorney and challenge that. And then if they were to challenge it, now they might be entitled to the trust because they're challenging it. They're throwing a flag on it. Now, this is where the judge would look at the trust and say, you have no legs to stand on, and now attorney fees might be awarded to the trustee because this was a fraudulent lawsuit. So legally, they're not entitled to a copy. That said, maybe you do want to show them the page that says that, hey, I acknowledge that there's this child out there who may think that they may be entitled to something. But typically the way we draw up a trust is say that we acknowledge this person is out there. We do not give a reason because they could challenge a reason, but we just say that we have not provided for them in this document. That's the way typically we handle it. It makes it clear. There's no question. There's nothing to challenge, right? Versus, let's say, I disinherit my son, John, because he has a drug problem. Well, now if 5 years go down the line, you pass away and John doesn't have a drug problem anymore, maybe now there's legs for him to challenge that disinheritance. So typically when we're excluding a child or any beneficiary, we do not give a reason. We just say we acknowledge this person's existence, but we say that we've intentionally not included anything for them. Because again, they do not have a right to an inheritance. No one has a right to an inheritance. Like when I'm working with my clients, I tell them the best estate plan is go when the last check bounces, right? And I have some clients that say, you know what, if anything is left over, that's gravy, but I'm not looking to leave anything to the kids. Versus I have other clients, I had a client today that they did, legacy was important to them. They had 7 grandkids and they wanted to make sure there was something left over for each one of those 7 grandkids. But understand, as a beneficiary, there's no right to an inheritance. We run into this a lot with like when maybe dad gets remarried, and now the kids are concerned, what happens if everything goes to surviving spouse? Well, dad is in control of his money. He can do what he wants. There's things that we can do ahead of time. But if dad wants to leave everything to the surviving spouse versus leaving things to the kids, dad's entitled to that if he still has capacity. So to answer the question from Anonymous, does an adult child who's excluded from a trust, are they entitled to the trust from the trustee? The answer is no. Legally, they're not entitled to that. But just from a family standpoint, maybe you want to share it just to prevent any issues in the long run. All right, so I think that is all the questions I had submitted. The last thing I have, just this is for just a little bit of fun, is who wants to see Joe Biden's tax return? Because it's public knowledge. So one of the things I did is I took a look at Joe Biden's tax return, and I did a tax analysis on that. So this might be a little bit different than your situation, but this isn't anything that you can't look at because it is public knowledge. But I was just having some fun one day and said, let me take a tax analysis. And this is something that we can do for your family of looking at the opportunity. So I did this for our vice president and president. So let's start with the Joe Biden and Jill Biden tax return. So this is based off of their 2019 tax report, which is public knowledge. They had a total income last year or 2019 of about $1 million. The total tax they paid on it was about $300,000. Interesting thing, and this is something I talk to clients about, is the difference between marginal tax rate versus your effective or average tax rate. So the way marginal tax rates work is even Bill Gates or Joe Biden, the first $20,000 is taxed at 10%. And then the next sleeve is taxed at 12, and then 22, 24, 32, 35, and 37%. So right now, a majority of my clients in retirement, they're in about the 22% tax bracket. And again, when the Tax Cuts and Jobs Act expires, this 22% is going up to 25%. So this is why we're having tax conversations of maxing out the 22 or 25% tax bracket. And then based on your taxes, that determines your capital gains, right? So this is that taxable bucket, whether your gains are taxed or not. And it's, again, based on your taxable income. So of course, for Joe and Jill Biden, they're maxing out the 37% tax bracket, which is going up when the Tax Cuts and Jobs Act expires. And this is something, again, I want to talk about. So Joe Biden ran on this promise of not raising taxes on anyone with more than $400,000 or less than $400,000 worth of income. Well, guess what? If he fully repeals the Tax Cuts and Jobs Act, if you're making $100,000, your taxes are going up because this will go up to 25% if he fully repeals the Tax Cuts and Jobs Act. Just something to keep into account. And here's something that's interesting. Where was it? So one thing that Joe Biden wasn't taking into account was qualified charitable distributions. So one thing, if you do have a charitable interest, you can have your RMDs going directly to a charity. and it lowers your taxable income. And one thing that he wasn't doing was taking into account his qualified charitable distributions. So that was something that I found interesting. And I did the same thing for the vice president as well. Interesting thing, vice president, they're actually they were earning more money on their last tax return than the president. But again, this is part of our tax planning. Is we're looking to see where are you falling in terms of these tax brackets, and then we can run different scenarios based on that. Of maybe we want to max out, like look at bigger Roth conversions or something like that. What if we wanted to do a $300,000 Roth conversion? What's that going to look at in terms of your total tax and everything? So just something that I thought it was kind of fun and interesting. But this is part of the planning that we're doing. Is really, we think a big opportunity and big risk is taxes going up in the future. And the big opportunity is minimizing taxes in two respects. One is looking at taxes in terms of your retirement and marginal income tax rates, especially with the Tax Cuts and Jobs Act, and then also looking at taxes through a legacy lens of estate taxes and what are you leaving to the next generation. So hopefully this was all helpful. I have to hop off. I have another call in about 4 minutes, and I need to catch my breath before I do that. But I just want to thank everyone for attending. Phil writes in, thank you. You are so welcome. I really enjoy this. Again, if you want to see how this applies to your situation, shoot us an email. Just reply to one of the emails. Let us know what you want to accomplish, and we'll talk about strategies to help you accomplish that. A couple more things. Gary, thank you. Anonymous, great presentation today. Thank you so much. Nancy, thank you. You're welcome. Anonymous, you're welcome. Excellent today as always. Thank you so much. Really my pleasure. I really enjoy these. Thank you so much. We'll do this again next week. Make it a great